case briefs, and so much more. LSData's got what you're looking for.
In a 1915 North Dakota Supreme Court case, Lynn v. Seby, a dispute arose over the payment for a partially performed contract. The plaintiff had agreed to thresh all the defendant's grain, but refused to thresh the flax, resulting in damage to the unthreshed flax over the winter. The defendant counterclaimed for that loss, while also arguing that the plaintiff shouldn't receive payment for their partially completed work. In this notable case, the court ultimately decided that the loss of grain due to exposure to the elements was a remote consequence of the breach of contract, and thus did not qualify for damages. However, they upheld the notion that the plaintiff could recover payment for the completed portion of the contract, despite its breach. The judgment for the plaintiff was based on the reasonable value of services rendered, rather than the full contract value. The defendant argued in vain that the plaintiff's partial completion of the contract should not be compensated. However, the court rejected this argument, and found that the benefits of partial performance should be recognized, while still allowing the other party to seek damages for the breach separately. The defendant was ultimately bound by his trial theory and unable to change his position on appeal. As a result, the plaintiff received a small judgment for their partially completed work, while the defendant's counterclaim for damages was unsuccessful.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.